Hi everyone, I'm Nicole Garton, President of Heritage Trust. Today we're diving into something that can feel overwhelming, but is absolutely essential when a loved one passes. What to do as an executor in Canada. You've been entrusted with a huge responsibility, probating a will, settling debts, distributing assets. It's no small task. But if you stay organized, know the steps, and act with clarity, you can walk this road with confidence. Let's break it down, clearly, simply, and without fluff, starting now. So let's start with the basics. What even is an executor? In Canada, the terms can vary. Estate trustee in Ontario, liquidator in Quebec, but the role is the same. You've been named to carry out the willmaker's last wishes, manage their estate, pay their debts and taxes, and distribute what's left to the beneficiaries. It's an honor and a serious legal duty. That means you must act as a fiduciary with fairness, prudence, and transparency, not favoring yourself or any beneficiary. This job can take months or longer depending on the complexity of the estate. You'll be juggling wills, court applications, inventories, tax filings, and endless communications. But if you follow a structured workflow and stay informed, you can move through confidently. And that's what I'm laying out for you today. First thing, start strong. You want to build momentum from day one. Record the date of death, even in your notes. This marks deadlines for probate, taxes, and creditor claims. Obtain the death certificate. You'll need multiple copies for banks, government, and financial institutions. Locate the will. It could be in a safety deposit box, the lawyer's office, or in a home. If you're unsure, search the Vital Statistic Agency's Wills Notice system. Arrange the funeral, if not already done. As executor, you're responsible for carrying out the deceased's stated wishes, within reason and the law. Notify key organizations, government agencies like Service Canada to stop CPP, OAS, to cancel the SIN, provincial healthcare programs, banks, insurers, utilities, and subscriptions, digital accounts like social media, email, memberships, and secure assets. Lock property, retrieve safety deposit contents, cancel the deceased credit cards, forward or halt mail, and ensure insurance remains valid. Start with clarity and control. These early steps set the tone for the entire process, especially securing assets and halting any fraudulent or unnecessary payments. Now let's talk assets, probably the biggest and stickiest part of the process. Inventory everything. Bank accounts, investments, real estate, vehicles, safety deposit boxes, digital assets such as cryptocurrency, loyalty rewards, business interests, personal property, etc. Use a Form 10 or P11 if assets are outside BC to document values as of the date of death. Valuation matters. For real estate or collectibles, consider appraisals. For investments, use closing market values. Even household items should be noted, often undervalued but still part of the estate. Jointly held assets like property or bank accounts may pass automatically to surviving joint tenants, no probate needed, but double check with the institution. Digital assets, make a list of any online accounts and passwords. These can be tricky to locate but often have monetary or sentimental value. Safety first, lock up property, confirm insurance is valid, especially if the residence is vacant, and protect valuables from theft or loss. Your goal here is full visibility. If you miss assets or misvalue them, it can derail everything else. Keep track of precise records, document everything, and track receipts for any estate expense. You'll need them for your accounting later. It's just as important to track debts and liabilities, because estates aren't distributed until claims are settled or properly handled. Create a debt inventory: mortgages, loans, credit cards, funeral costs, unpaid bills, back taxes. Notice to creditors, optional but strongly recommended. Publishing a notice in the BC Gazette protects you legally and gives creditors 30 days to come forward. It costs about $64. Hierarchy of payments: the Wills, Estate, and Succession Act rules. Secured debts, estate administration costs, funeral expenses, taxes, then legacies, then the residue. Special scenarios: if the decedent was behind on spousal or child support, those claims become estate liabilities. If the deceased was divorced or separated, estate assets could be subject to family law claims. Seek legal advice. Sometimes small estates or jointly owned assets need no probate. Banks may release funds with indemnity letters, or property titles can transfer by death certificate only. Never distribute a single cent until you've handled liabilities and confirmed that none exist. Failing to do so could expose you to personal liability. So taxes are often one of the most confusing parts. Let's simplify the executor's tax responsibilities. File the final T1 returns. One for the year of death or later by April 30th or June 15th if there's business income. Possibly prior year returns if they're not filed. You're responsible to complete them. Estate trust, which is called a T3. If the estate earns income while it's being administered, you'll likely need to file a T3 return for fiscal periods up to 1 year. Capital gains. The CRA treats all assets as sold at fair market value on the date of death. Capital gains taxes may apply. Apply for the clearance certificate from the CRA before distributing estate assets. Absolutely crucial, or you could be personally liable for unpaid taxes. Non-resident beneficiaries. Special tax rules apply. You may need a certificate of compliance or withhold taxes. Get advice from your accountant. Elective returns. Consider the rights or things return, the graduated rate estate election, or partnership income returns if they apply. These can reduce the overall tax payable. Once again, make sure all returns are filed and the clearance certificates are obtained. Only then can you distribute. And if the estate earns income post-death, treat it as a mini trust account for it. Finally, distribution. This is what most executors look forward to, but you still need to take careful steps. Wait for the creditor period to expire, which is 30 days after a notice, and the will's variation window, which is 180 days post-probate. Provide an accounting, asset values, expenses, liabilities, distributions planned, and executor's fees, which can be up to 5% of an estate value. Have beneficiaries sign releases acknowledging and accepting the distribution and releasing you from further claims. Return assets, bequests, and residuary amounts according to the will. After distribution, you can apply to the court for a formal discharge. This protects you from any future liability arising from your administration. Keep all estate records, bank statements, receipts, and legal documents for several years in case of a follow-up or audits. Distribute confidently with transparency. Showing everything to beneficiaries and getting a release protects you and gives closure. So what are some tips and common pitfalls to avoid? Before we close, here's the things to avoid. Stay organized. Use a notebook, spreadsheets, or executor binder with sections, tasks, timelines, documents, and expenses. Track time and money. Keep receipts, note your hours and mileage. They can often be reimbursed. Don't act solo. Get legal and accounting help when needed. This isn't about saving money, it's about reducing your liability and ensuring accuracy. Avoiding gifting assets early. You must be clear that all steps are done before distributing. Beware of unresolved claims like missing heirs, creditors, or family law issues. Ensure they're resolved before distributing. Always maintain communication with beneficiaries. Provide frequent updates as they build trust and reduce conflict. Acting as executor isn't glamorous, but you'll feel immense relief and confidence if you do it methodically and transparently. So there you have it, a comprehensive roadmap for the moment you accept the role into your final discharge. It's not easy, but it's doable, with structure, clarity, and patience. And the greatest reward, knowing you've honored someone's legacy with care and diligence. If you found this helpful, hit the like, subscribe, or ring the bell so you don't miss our future guides on estate planning, trust management, and more. And if you would like a downloadable checklist or printable flowchart based on this video, head to executor-guide.ca. Thank you for watching and stay organized for them and for yourself.